2016 into, into 2020, I feel like I had already kind of started to understand the challenges that we were going through, but also the difficulties working within the federal system, trying to obtain rights through impact litigation. I think when I went to law school, and perhaps like a lot of other people that are interested in law school or in law school or that are currently practicing, I thought of impact litigation as litigation in general as, we're trying to get benefits for as many people as possible in one kind of vehicle, right? And so the notion of impact litigation is, I think, attractive in that way because you have the opportunity of bringing a really large class action. You can have wide-ranging change for thousands, tens of thousands, hundreds of thousands of people if you play your cards right. The thing that I realized in my practice was, despite the possibility, right? Us being able to imagine a world in which impact litigation could be successful. The problem is that the mechanisms by which we attempt to, achieve change through impact litigation have always been super slow, right? Even if they are ever successful, the problem is how long do you have to wait? How much do people have to sacrifice in the interim in order to ultimately get to that kind of victory? And in my work, those victories never kind of materialize, right? Working on these cases year in and year out, but then leaving a fellowship, moving to another fellowship, working on a case that has already been 7 years in the making, right? The issue that I felt like I ran into was that I wasn't feeling the change happening in the moment, right? I'm going to my client in prison saying, we're working on this, we're almost done with the lawsuit, but the material conditions of my client's confinement are not changing in any meaningful way. The one benefit or the one moment that I felt like I actually was able to accomplish change was in that that individual representation scenario, right? Working on a juvenile life without parole case, we're building again a class, trying to build a class, trying to push impact litigation, but ultimately the thing we were successful in doing was getting someone released, right? One person, right, who had ran a red light as a kid, crashed into a car, killed a family going to church, right? In rural Louisiana, in a place where Black people are already and consistently and continuously targeted, right? And so being able to get one person out of jail who had spent 30 years there already, who already had documented, intellectual disability and multiple reasons why they shouldn't have been put in a cage to begin with, right? So getting that one victory in the kind of scope of impact litigation, for many people would feel like that's not what you're there for. That's not why you're investing all of these resources, all of this money. But ultimately was the only victory I was able to obtain through impact litigation. And that made me want to leave that space. Oh, sorry. That made me want to leave that space and to move into a policy space because I felt like it gave me the opportunity to do things that were a little bit more, had the impact at the local level, had smaller impact, didn't have the reach that impact litigation might have, but still would make meaningful change at the individual level. And so I'm happy to talk more about kind of where I think policy and legislation has opportunities for us to achieve that when we're seeing, again, a federal judiciary, a federal legislature that is failing at every opportunity to really create change that we hope and voted in many instances to try to create.
Hi, everybody. My name is Annika Dunbar-Gronke. I use they, them pronouns, and I am a Skadden Fellow at the Lawyers Committee for Civil Rights Under Law. My project it's interesting. So I get to do a little of these things, direct services, and I also get to do work at the policy level, not enough to disrupt the C3 status of the organization, but I do get to do a little bit. I track my hours. And then there's also some transactional work with cooperatives and land trusts, and I'll explain probably throughout this panel why all of those things, I put all those things together, and it's not just because I'm highly distractible, although that's true. So my project, or the work that I do, in addition to working on some of the impact litigation that the Lawyers Committee does, I work in the Fair Housing and Community Development Project there, is centered around decommodification of housing and land in service of the material needs of poor Black people in Baltimore City. And I feel really lucky that I get to do that work specifically, not only because I get to center poor Black people, because there are so many legal spaces where it's like, yeah, we're centering the most marginalized, and my personal theory of change is rooted in Black queer feminism, which is always going to be centering Black people, with the understanding that in the system of racial capitalism, if things are getting better for Black people, for queer Black people, for poor Black people, for the most marginalized, for disabled Black people, then I am so sorry, I can slow down. Just ask me to slow down, that's okay. If we are centering that, then things will actually get better for everyone. So there are sort of three buckets of work that I do. I do direct services. I represent folks in rent court, not nearly as much as Vic does, but enough to see a lot of the same things that he was talking about, where when you come into a courtroom, on one side there are a bunch of tenants, and you can tell that it's all tenants because it's all Black people, and then on the other side you have a bunch of white folks in suits, and those are the landlord's attorneys. And sometimes there are Black folks on that side, but typically it's because they are the property managers, and so they show up and they come up to the front of the, come up to the bench and are talking about, they are become a tool of, pushing other Black people out of their home. So they'll come up and they'll tell the judge, well, this person acted this way, this is what's wrong. And it's hard to see. It's really hard to watch, for me personally, but that's just one of the many dynamics that's there. And then the second bucket of work that I have is I get to support tenant-led organizing in Baltimore City. There's a really beautiful history of resistance among primarily Black renters in Baltimore City, particularly in the 60s and 70s. There were rent strikes, there were against conditions. There were some people just didn't want to have like a white man managing the property anymore. So they protested and showed up at people's houses when they definitely didn't, these white landlords definitely didn't want these Black people showing up at their houses, to get a lot of really powerful changes passed, including rent escrow laws that we still use today. And then on the third bucket of work, I have to shout out Baltimore Renters United, which is a tenant group that I work with, and that has launched in the last week. They had their first citywide meeting, so that power is being built, and I feel really fortunate to get to work with them. And then the third piece of work that I do is supporting community land trusts and housing cooperatives that are being established and built by and for Black people. That was a long introduction. I am so sorry. I'll answer now the question. I told you I was highly distractible. How are the decks stacked? I think about it so I get to think about it on the legal side as well as the organizing side, because that's how my time is split. And I think on the law side, one of the big issues is that we've been misled to thinking about the work that we do from a rights-based framework as opposed to a resource-based framework. Resources and a more equitable distribution of resources, I think, has actually always been the goal, and civil rights was supposed to be a proxy for that, and it has not been because racial capitalism. But since we've been stuck with that, and so much of the language that was formed around sort of like civil rights, and we end up making these arguments in legal spaces that are really nice. They sound so nice. We're like, yes, equity, justice, but it's never reparations. It's never, protect poor people. It's never anything like that. And so that's one way that we end up, that the decks are stacked against us in the law side. And then the other is that we have a lot of local judges. And Vic and I were talking about this earlier, who are just like not accountable in any way. A lot of people are not paying attention to judges' races. Sometimes they're appointed by, whoever the powers that be in the state. They're not accountable on appeal. In Baltimore City, you can't appeal an adverse judgment functionally as a poor person. especially as a poor Black person, because the bond that gets set at an appeal can be basically whatever a judge wants. And I've seen, bonds be up, $18,000, $20,000. You know how long you have to get that money? 4 days, 10 days. And so if you've got a failure to pay rent case and you already can't pay your rent, that's just not going to happen. So you don't have access to the courts in the same way. And then I'll wrap it up by saying, like, on the organizing side, the deck is stacked against folks because one, because displacement is disrupting relationships necessary for organizing. Organizing requires relationships and it requires trust. And if everybody is being scattered all over the place every 6 months in some folks' cases, organizing just cannot, it's very difficult for organizing to happen. And then the other thing is that, the permanent underclass that is required under racial capitalism means that when we're talking about I think that Tenji Wei talked about it the other day, we have to be addressing the material circumstances of folks, and it just makes it really, really difficult to do so because everybody is just strapped. People are trading, people borrow each other's food stamps cards, and the people that are, all the time, and that's a beautiful mutual aid practice. And also it's just not enough. And so figuring out how we can get more resources is good. I am so sorry, Karen.
Don't be sorry.
I'm so tired. I have made terrible choices.
I mean, I think this is super helpful, right? So I've heard a rights-based framework versus a resource-based framework. And I also just want to add the way in which anti-Black oppression is so baked in at every facet and stage of law, whether it's indirect, whether people are reacting to litigation brought against them in the criminal context or in the housing context or another. And the consequences of either direct appeals or of litigation of arguments we think might be righteous, arguments under anti-discrimination laws, arguments about racial issues in the criminal context. But I'm very excited to have the three of you here because you are brilliant litigators and thinkers about this and are approaching it thoughtfully. And so I really wanted to have folks talk about some of the ways in which being thoughtful about this fact, we can come at legal issues from the side, from underneath, from behind, picking procedural postures, doing more than litigation or outside litigation to try to get at those righteous issues. Again, with a broader view of, I am a lawyer today, how can I do this the best, given the stacks that we have. So Vikram blew my mind talking about the mandatory diversion from eviction program in Philly. And so I thought maybe you could start us off talking a little bit about how that came about and how you're addressing it now because of the efforts to weaponize this against clients.
Thank you. Okay, so I'm gonna kind of talk about two separate but related things. When we're talking about, lawyering when the decks are stacked, we're essentially talking about not, an environment that's not built for our clients, an environment that's not built for us, and what it is to operate in that environment. And I think there's two separate tactics that I'm going to talk about. One is moving to a different environment, which is going to be the eviction diversion program. And two is essentially making that environment also dangerous for our opponents to operate in, to sort of raise the stakes on their side. And the opponents are landlord attorneys, at least for me. Okay, so first, the eviction diversion program. So it's in Philadelphia, pre-pandemic, there's like 19,000 eviction filings a year. I just talked about how 8% of tenants were represented before, some of the work that we were doing with like the Philadelphia Eviction Prevention Project. And it's a very fast venue, right? Go from a filing to a lockout in just a couple months. And most things are done through default judgment, yada, yada. So at the beginning of the pandemic, we and a bunch of other tenant advocates and our some of the newer city council members, we're looking at what are some of the solutions that we can look at to change that environment. And one of the things that we came up with was this mandatory eviction diversion program, which essentially is a requirement outside of court to go through mediation before even having the right or ability to file in court. And it's expanded. It's gone through various different iterations, but its most recent one now requires like all cases. So no matter what's going on, with the very small exception of imminent harm, you have to go through mediation outside of court before being able to file.
And does this exist anywhere else
You know,
that you know of?
I mean, I don't know. I guess any programs that are of the same scale. There's definitely eviction diversion programs, and even in Philly there was an eviction diversion program, mediation program that existed before. It just wasn't mandatory, and that mandatory that change to making it mandatory is what I think has really led to some of the success around it. And it was a huge threat also to the landlord, to the landlord attorneys, and also to the landlords. Immediately after City Council created it, they filed a federal lawsuit to try to invalidate and get rid of it, which they did not win, thankfully, which was great. So some of the things that we did to sort of get that in place, first was we had sort of recent change in city council, got some city council members who were elected who were much more friendly to that sort of change, especially considering how in court that was not something that we could have gotten that change in. We had a supervising judge at the time who was very antagonistic toward tenants, actively antagonistic toward tenants. We shifted to a legislative approach in order to create something that was completely separate from the court, to move into a venue where it would be more friendly toward our clients, and a different space for us to operate in. And I'm going to save the other thing for a little bit later because I've been talking for a while. Okay, I'll talk about the other one now then. So the other one I was going to talk about was essentially going after landlord attorneys. So I mean, one of the things that makes I guess eviction court such a friendly venue for landlords and landlord attorneys is that it's a space where the bar for them is so low. There's a handful of attorneys that are able to essentially run eviction factories. Like they show up, they got a stack, they get 40 default judgments, or for the ones that they don't get default judgments on, they understand the law, and they're essentially coercing people who aren't represented into taking deals that are very detrimental to them. Now, as part of that, essentially running an eviction factory is that you're sloppy also, right? Like, because the municipal court is not going to hold you accountable. You don't take that extra effort as a landlord attorney to make sure that all your filings are correct. So one of the approaches that we took, and this was just after the creation of the eviction diversion program, was to pick a particular landlord attorney who was violating local statute, and file a federal Fair Debt Collection Practices Act lawsuit against them. Essentially putting all of the other landlord attorneys on notice that if you're filing things that you don't have the legal right to, if you're running an eviction factory that is essentially rolling over people, you're going to be liable, and we're going to take you to court. Essentially, yeah, using this space that's dangerous for our clients and has been dangerous for our clients for so long, and sort of turning it on its head so that it's dangerous for those who are causing all of this harm and running an eviction factory.
I just want to jump in there also because I really appreciate that specifically because the danger is a loss of resources. It's always about the resources. And so I love this idea of making for as many people, as many of the folks who are enabling this awful system, like making the environment so toxic. I want to make an environment so toxic that there's not a single landlord attorney and a single attorney that wants to be a landlord. And I think that we've done it. I know in a lot of ways we've done a good job with that with prosecutors. Who in this room wants to be a prosecutor? Do you? I don't. Because I know that everybody would come for me all the time. Absolutely, yes. Make the environment so toxic that nobody is trying to do this. That's beautiful.
And really taking advantage of the fact that there are essentially 5 landlords attorneys. There's this like monopsony of landlords attorneys. The single buyer, like there's one buyer, and they are the landlord's attorneys. And if you can scare them or go after, them, that's the whole show. And so, yeah, such a powerful like point to enter into.
Well, this I think goes back to some of the things that we saw yesterday in the afternoon plenary about walking into a space, and when you walk into a space, you're walking into a space that you want essentially the other side to be scared of you, right? Like we think about the law and we think about our profession as such a collegial place. Like it's a value that our colleagues will talk about. But what we give up in that also is in that collegiality, we're buying into a system that is actively harming our clients. So it's I don't think we should be afraid to when it's needed to throw that collegiality out the window, because and the thing is actually what ended up happening as a fallout for that was that particular landlord attorney, like I can't work with him anymore. Like when I show up in court, he just yells at me, like we get in fights. But all the other landlord attorneys, before they file a case that they think is a little bit iffy, they'll come to like me and my colleagues and be like, I just want to make sure that, everything's above board. Can you like, what's your interpretation of the law? Oh, okay, I can't file that. Okay, well, it's okay. I'm gonna hold these, 30 or 40 cases. I will wait another 2 months before filing them. So it would seem like a huge shift in culture. So I did burn one bridge, but it opened up a space for my colleagues and me in order to operate in a different manner in eviction court.
Excuse me?
I said there's nothing wrong with burning a bridge you don't want to cross.
Mood. I just want to jump in there because I'm gleaning a couple of different things that I feel like are really interesting. And one of the things we had talked about in kind of our preparation for this was this concept of guerrilla advocacy. It had been coined in a kind of a different context before. I cannot remember the name of the person right now. I'll try to find it, but the context was kind of using what were initially kind of business school concepts relating to marketing, guerrilla marketing, and applying it in both the legislative and the litigatory, I guess, or litigation context, right? So we think about guerrilla warfare as a concept, right? The kind of the hallmarks of it are that it is decentralized, right? It is makeshift, right? It is about using advantages of the environment that you are currently in, as opposed to the broader kind of the broader environment itself, right? In order to create advantages for yourself, right? You bring your enemies to you in a place that you've already kind of set up an advantage in, right? And I feel like one of the things that we as legal workers have always done when the decks are stacked, right? Because we should make clear that the decks have been stacked in one way or another forever, right? I think it's just about where the decks are stacked at any particular moment. But for example, we have public defenders up here right now, and public defense has always been a stacked field, right? There's never been a moment where public defense has really been had the upper hand, right? And one of the things that you notice in these spaces where the decks are stacked is that specifically as litigators, you use legal process itself as a tool, right, or as a weapon. If you're, if you have a client and the record against them is not favorable, you're going to use every piece of legal process you have available, right? If the cop didn't do one piece right, you're going to make sure you file that motion. It's going to gum up the works. It's going to delay the process. It's going to make it easier for there to be a more favorable plea or to get your client out entirely, right? And even again, if the ultimate goal or the likelihood of release is not high, right, you're at least again creating opportunities for more advocacy in different forms while that process kind of moves forward, right? I mean, we also see that happening politically in the legislative process, right? You think about the Trump impeachments, for example, right, or any of the January 6th investigations that are happening now. When people want to get information about what actually occurred through legal process, through contempt of court proceedings, et cetera, there's constant legal process being utilized to slow the process down. And functionally, what you hear people say is, oh, well, it's not worth going through the process of trying to obtain records from Trump Organization because the legal battle to get that will be longer than the time we actually have to produce a report, right? And so often we see legal process being used in order to prevent us from accessing resources, right? As opposed, let alone, we're thinking about rights, but forget rights. It's not about rights here. It's about how do we access the resources that we need through the process. And so that's why I like this idea of using, landlord, like targeting not only landlords, but also targeting the people that represent the landlords, because it is giving you another kind of tool, another strategy to gum up the works, right? If they don't like, being targeted as attorneys representing landlords, they're also going to change their behavior. The landlords are going to have to find new strategies and scramble in that regard too. It puts them on their heels. And then the other piece that I wanted to mention is again, you can't get things like a mandatory eviction process through the courts. They're not going to give you a right to mandatory, mediation or arbitration, right? Those are things that are only going to happen at the local level or through legislative action, or in this case, through city council action. And so the thing that I've been thinking more about and why I've wanted to pivot more into the legislative space is because it just simply is a bigger laboratory for us to try these things out, right? If we're constantly focused in the courts on trying to obtain and secure and define rights, it makes it harder for us to talk about things that may not be rights, but may be resource beneficial, resource generative, right? Where we don't need to necessarily, the government may not owe this to us, right? But nevertheless, we are compelling the government to do it. We are bringing people into these positions of power to create systems that we could only imagine prior to, right? And so I that's why I feel like in so many instances when we're trying to do things through litigation, we have to be creating the right playing field for ourselves, right? We have to be making sure that we're creating the right environment for success, as opposed to kind of just going through the motions wherever we can.
Cam, can you, I just want to call out some of the amazing, because you have described to me, the policy goals of your clinic, and maybe you could tell us briefly what that is. And then in an effort to nationalize the changes, to build on the success that happened in California, you've described such a great example of this guerrilla advocacy because of the need to be particular and to be extremely specific to the location that where you're trying to make the next change. And I thought Texas was also a great example to throw in there.
Sure, absolutely, yeah. So as I mentioned, we do specifically juvenile fee and fine repeal legislation, a very, very niche topic that Sure, juvenile fee and fine repeal. So specifically, if you think about a kid, they're tagging a building, they're putting graffiti on a building, they get caught, they get arrested, they go through a court process, a number of different things that occur. They may be put in detention, they may get served community service, right? But regardless of what the actual adjudication is, what the result is, oftentimes there are fees and fines that are built into the process. So say if you have a kid that has picked up a drug charge, they may have to go into a drug education program. That program itself could be $300 out of that kid's pocket, right? In many cases, we've seen mandatory fees established, $250 for DNA analysis, things like this where there's no negotiation, there's no discretion, but even of course, when judges use their discretion, a lot of times that is another opportunity, another space where racism is involved too, right? Because it's a question of how much money do you make, but also what do you look like and how do you carry yourself? And if I don't think that is what is defined as poor, then I'm going to think that you have the capability to cover these payments, right? Again, this is judges talking to 16-year-olds, 17-year-olds, people who barely have access to being able to take on a job and develop income, right? So often this is creating systems where families are struggling, they're trying to pay off debt for their children, and it's ultimately kind of snowballing in those really, really challenging ways. So we've been attempting to repeal these laws at the state level for about a decade now. The Policy Advocacy Clinic started in California. It's in, Berkeley's in California. And so they started local, took them multiple years to build out a process where not only did they, eliminate the fees and fines that were on the books, but then they also made that retroactive. So they discharged any outstanding debt that that families had still taken on. So millions of dollars that were still payable to the government, to the counties, was ultimately discharged, right? Massive relief for families in the state of California. And so we began to expand that strategy out around the country. Right now, we're in over a dozen states. We're doing work primarily in the Southwest and the Deep South. We're doing some work in the Pacific Northwest as well, and also here in the Midwest. So I work personally in Illinois, Texas, which is my home state, and in Hawaii. And so, of course, doing this work in different legislatures is going to be very vastly different structures, systems. Literally, the governments operate differently, right? But the politics is always going to be different, and understanding how to navigate the unique kind of challenges of each state is always going to be hard for us to do. And so the example that, that is really instructive, I think, of how we use these systems in the Dexter Stack was in Texas. So of course, Texas is not the state that's most amenable to freeing kids from cages or, eliminating financial burdens on poor folks, right? That is not their prerogative. But one thing that they do care about is the administration of their courts and fiscal responsibility, right? And so the way that we were able to ultimately get half of the fees and fines on the books in Texas repealed was by framing it as a court administration issue. The fact that the courts are not being properly funded, and that's because you're relying on poor people in order to keep your government running. You're relying on these folks in order to pay these fees and fines for there to actually be services available to begin with. And that's ultimately the crux of the issue. And so being able to kind of couch that in a bill, again, that was focused on court administration, very boring bill, right? Included in a repealer section. So not even making specific references to the fees and fines, but just saying, we're going to repeal family code section, XYZ, right? Don't worry about that. You don't need to know what that is about. It's no big deal. And being able to go to legislators on both sides of the aisle, right, to be able to say this is just a court administration bill, very simple, very purely administrative. Just sign, just say yes to the bill, right? You're not going to get any fallback on this, right? And that was successful. Ultimately, by kind of sneaking it under the radar, very Trojan horse style. Ultimately, there are still remaining fees and fines on the books, and we're actually going to be attempting to do the same strategy to get those ones off the books, right? We're going to have to try it again. Obviously, it's going to be a different scenario. They may kind of catch on to what we did, and so we may have to do something a little bit more in the guerrilla advocacy space.
Everybody is sworn to secrecy.
Exactly, right? Like we're keeping this.
Don't go telling the Texas legislature.
Right, keep it quiet, right? But yeah, so like it just goes to show that there are so many. Again, we have to try different strategies depending on where our location is. And it gives you, again, this place to use these different states as laboratories for this work, right? You can't do that at the federal level. That's not going to work. But at the state level, it gives you opportunities to try things, to potentially fail at them, and then use those that knowledge that you generate in other contexts.
Yeah, I just, this is great. I'm so excited. I feel like I have bits and pieces of this conversation with different people all the time, and it's really great to have it all here. And so I think I struggle with like a question about like what's creative. I struggle with the question about like what's creative, because so often, like this competition in lawyer world about finding like the most creative litigation to like do the most creative thing. It's like ends up not being helpful really. And so I try not to, and there's nothing wrong. I get that that's not the question here, but I am recognizing the resistance that I have to that word for that reason. Being at like a big, nonprofit organization that has done impact litigation in a very traditional form for many years. However, this is the time that I want to talk about why I chose those 3 buckets of work for my particular project, which was when I applied for to get funding for this project. The way that I came up with it was there was concerns about an eviction landslide in March 2020, and so I got involved in just sort of local organizing efforts in Baltimore City. There were a bunch of folks who were actually Movement Law Lab was part of. I got connected with them to do organizing of attorneys in the Mid-Atlantic region to figure out how to respond creatively to that. And through that work and being engaged locally, there were folks I came upon or learned about the efforts that folks were doing in other places to do participatory housing defense. It was an interesting idea. It was something that I offered to folks locally as something that was happening in other places. And there were a number of organizers who were interested, but they were like, we can't find an attorney who is available to support that space. And there are a variety of reasons why having an attorney supportive to that space would be helpful.
And what is it? What is participatory housing?
Yeah, so participatory, well, I mean, it's in progress right now, but figuring it out, but it is based off the model for participatory defense in the criminal space, which is an intentional organizing model wherein folks who have cases or who are directly supporting family and community members who have active cases gather together, discuss those cases, support each other through those cases. If somebody has like a shitty lawyer, they can be like, you know what, I had that shitty lawyer, this is how you need to deal with it. Everything from like that to like showing up to each other's cases when there are hearings to like show community support, all of which is like, again, like material support. It provides that for folks, and that's part of why it's powerful. And then through that just like processing of these cases in community with folks, larger issues are identified, and then can become a good Christian. You're just shaking your head because I know you know. I feel like I'm doing it right. If Noah's telling me that is nodding, then I feel like I'm doing the right job with my explanation of it. But like through that processing, larger threads and sort of like larger themes of oppression are identified to then organize around for bigger campaigns. And so the idea is to do the same thing in the housing space, and it's a little bit more difficult with housing because in the criminal space there are particular safeguards because liberty is a very special right that has some protections, increasingly fewer protections, but there are a number of moments of intervention with when someone's freedom is being threatened by the criminal system, but with housing we have summary ejectment procedures. So, we definitely don't get mandatory mediation. No, I didn't, if your date changes for your hearing about whether or not you're gonna lose your house. I had this happen the other day. We had a hearing scheduled for, the end of July. Come to find out, it actually got moved to the beginning of June. Did my client get notice? No. Did I get notice? Hell no. You wanna know why? Because the Baltimore City Court is on paper. It's not on the internet. I can't look it up. So that kind of thing makes it really difficult to have that kind of community process. So figuring out ways to, anyway, all that to say, thank you for inviting me to explain that. All that to say, there was interest, and I was like, and they were like, we don't have a lawyer because the public interest lawyering community in Baltimore City is like, it's sparse, and everybody's strapped for time and resources. And so, but I was like, oh, I'm a lawyer, I can do that. I'll get some money. That was the whole point of going to law school. So I applied for it. And then I was like, I had to like missed all of the application deadlines. I did it backwards, it turns out. The way that, and I say this to say that often the way that we come up with campaigns is specific, particularly in places like SBLC, and it's changing. I think that folks are interested in changing it, and the Lawyers Committee, LDF, all these legacy organizations. The idea is that you go to the organization will know the things about what needs to be done, and then you make connections with community later. And I didn't know that. So I made the connection with the community, and then I was like, oh, I got to find an organization to host me. Shit, I need some supervision. I had missed all the deadlines, and somehow the lawyers committee accepted my proposal, and now we're here. But in order to fill out scaffolding to support the development of a participatory housing defense space, thought about what Andrea Ritchie has said for a long time, which is you need to be doing direct representation if you're going to be doing any of this, because tactically, not only like tactically in support of organizing, that's a helpful tool that shifts folks' material circumstances, that brings them into the work, that supports them in continuing to do the work. That's good. But also, if we are not trying to work ourselves out of a job, we're doing it wrong. And so I'm doing a lot of work. That's where the community land trust and housing cooperative piece came in. I was just like, I don't want to be a lawyer. I want to be on a beach drinking a mango-based alcoholic drink. That's what I want to be doing. I do this in the meantime, but we're going to get there, right? And so developing tools that would permit permanently affordable community-controlled housing is the end game there. So so connecting all of those things were important, but the creative spaces in each of those buckets of work, in the direct rep space, being able to connect clients to organizing was really important to me. So I really do, the citywide meeting they had, all my clients got notice of that. And that's supportive of the base building that's necessary to make the organizing more powerful. We can do that. It's unfortunate, I think legal aid places, I'm not sure. I think that there's different levels of hesitancy in legal aid organizations to provide that because of funding restrictions, which are fucked up anyway. There shouldn't be those LSC funding issues, but I don't have that, and so that's a part of my intervention. And then in the advocacy space, access to certain advocacy opportunities are dominated by lawyers to the exclusion of marginalized folks, always, particularly state level advocacy. And given what we've seen in the federal courts, and the fact that we are not going to be able to bring really great federal cases or helpful federal cases for the next 60 years, we're just not. We know that. And so what are we doing at the state level, and how are we making sure that the advocacy spaces are not just sort of like folks like us who are like, oh, well, I've read the stuff. I represent clients. And so I know what the clients are going through. But because what ends up happening when we do that without partnering with folks and ensuring that the advocacy spaces are made for and centering the folks who are marginalized, is we become a buffer for the elected officials to avoid talking to those folks. We do that so often, and it's not intentional. It's not a bad thing, but it's happening. It happens all the time. I see it in Baltimore City. I've been somebody, but it was actually really interesting recently. I had a city council member call me, and he was like, well, this thing's about to happen. Baltimore's real gossipy. It's great. There's lots of we can talk to you about Baltimore anytime. But he called me and he was like, this thing is about to happen at the city level. I wanted to give you notice. And I was like, it was a moment of intervention. It's not that creative, but I took a step back and I was like, you know what? Hold on. I need to pull our organizer on the line. I'll call you right back. And that's something that hasn't been happening because we've been in this place for lack of having a base, that those relationships with city council members, everyone guards them because we're like, this is all we have. But when organizing, and when there's a base, when there's organizing, when you have relationships with the folks who are organizing, and you demand that they get to be in these spaces, first of all, they stop calling you. And that says something. That tells you about whether or not, how much they're on your side in the first place. So you can then shift your tactics, shift your strategy with that understanding. But it also ensures that the spaces that are created in the future are actually not serving as a buffer or protection for elected officials from their own constituencies. And then the final piece, just in the policy work, prioritizing bills that promote and protect organizing and collective action around any topic, I think is also really important. It's something in Maryland, we brought a bill, or we worked with a delegate to put together a bill called the Tenant Justice Act this year. And what it would have done if it had passed, and we're going to keep working on it, is it would have mimicked this this process that's available in New York, wherein tenants can bring an action about conditions in court altogether without doing escrow and without risking. And it can be about, they can bring, they don't have to file like a class action together. They can just bring something together. Folks can put their names on it, or one person can come in and say, the conditions in the building are shitty. It's all of these units are affected, and they don't end up in a position where there's like all of this like coordination that becomes so disruptive to organizing that it ends up not being worth it. It takes all this time and resources away from the organizing, and folks don't have to put money into escrow.
Do you mean to tell me that people have to put money into escrow before they can bring a lawsuit, before they can access the courts to get a remedy?
Yeah.
Could we just pause on that for a second?
Yeah, absolutely. And you know who doesn't have to do anything like that when there's an issue is the landlord. You know, like if
Put in escrow the amount of money it would take to fix the condition, the rats and the termites in the bed, but like,
yeah, makes no goddamn sense. No, so and like I think measures like that are so important, because again, we get caught into this rights-based framework that lead everyone to continue to look to the state to fix things, and then we trust that the state's going to do that when it continues not to do that. It has never done that. So like it's at the local level in Baltimore City, and this is the last thing that I'll say, there was this same city council member is working on a licensure bill, a bill that would enforce rental licensing. We have a rental licensing law. Landlords don't follow it. They can still evict people. It's super fucked up. It doesn't make any sense. But he's trying to strengthen that, right? And we were really fighting to get written into that bill a private right of action for tenants, so that they could be the arbiters of the enforcement of this law. Because what we know in Baltimore City is that the Department of Housing and Community Development, there's a lot of things that it's supposed to do. Does it do them? No, it just doesn't. But we got so much pushback from the city, legal department, because they were saying like, you can't do that. You're not allowed to have a private right of action. And so we ended up having to concede to an administrative remedy to enforce that folks could like call the city and like ask to do this administrative remedy to enforce the law that would then be on the books, right? But guess who's putting together the administrative remedy? Who is the arbiter of the administrative remedy? It's the Department of Housing. They already don't do their job. So why would we add more responsibilities to their plate, more power to them that they're just not gonna, enforce? And so thinking about that and making sure that what we're doing if we are creating a law, if we are creating a protection, putting as much power into the hands of the people who deserve to have that enforced is helpful. And I think that's like, in a lot of ways, that can be abolitionist, right? Like that is like, we are supposed to be holding each other accountable in community. We're supposed to be able to, self-govern. And there are so many ways that that's criminalized, and like but if we're actively working on policy changes that are taking power away from the state, that are encouraging folks to, enact to enforce and hold folks accountable themselves and in community with one another, then that's those kinds of interventions I think are particularly going to be particularly helpful and necessary, particularly when we don't have the Supreme Court or federal courts to be able to go to for broad-based solutions.
I had a quick follow-up to add to this to talk about private right of action, because this is something that we've been thinking about a lot, and restructuring how we talk about our legislative action advocacy, but also I think we're going to be getting to questions pretty soon. So think about your questions. Do we have Mike? is there a question, Mike? My question? No. Okay. But yeah, one of the places that this private right of action has come up for us has been with illegal evictions. Because on the books for years in Philly, there's been I guess criminal consequences for illegally locking someone out. But we've you essentially, right, you're depending on the state to enforce that, right? And it's not something that we really ever saw the police or the DA or anyone enforcing at all in any way, shape, or form. So one of the things that we were looking at when we got the diversion program created at the same time, there's a whole collection of bills, and one of them was to create a private right of action against that a tenant can bring against their landlord for illegally evicting them. And some of the things that we really had to consider was how it's structured in such a way that it's easy to use and easy to access. Because we as tenant advocates and legal services attorneys, right, we don't have the resources to bring all those cases, and we shouldn't structure these laws in a way that it's built for us. It should be built for our clients to be able to use to empower them to bring those actions.
I'm so sorry. Does everybody know what a private right of action is? Okay, just, not everybody does.
No, I think that's great. I mean, one of the big through lines I'm hearing is just really, and why I love you all three so much is that you're keeping the focus on the folks most impacted. And I know, because I know you, that your own legal practices like carry a queer Black feminist lens where, where that's informing like how and who and how the support happens in sometimes a resource constrained environment. And I just want to touch very briefly on the criminal context. Like, does anybody out here work in the criminal space? Yeah. So, folks are hostage. They're hostage in that situation. They don't get to, it's not like who's a good plaintiff in that really fucked up conversation, pardon me, but it's just everybody who's there, must respond to the situation that they're in. And I saw, and sometimes with, if you feel you have a righteous motion, you litigate it, you lose. That's a bad outcome. You decide whether or not you're going to take an appeal. That can be a really important decision depending on where you might be driving the law. In the federal context, I want to call out the Federal Public Defender's Office in the Northern District of California because of how they used like the concept of audience and of litigation to both get information and to benefit a particular client, to focus and center their particular client, in this case, a Black man who, where this arrest was super racially motivated. It was very clear from every stage. However, basically the way you have to bring that up in the beginning of a case is through something called selective prosecution. And the bar to making a good case for that is so high, it's basically impossible. And there's a world in which, especially in the federal courts where you could appeal and you could pretty quickly become precedential, you don't want to necessarily bring that motion for risk of creating bad law, especially look at your circuit, look at your district judge, it's a nauseating situation. So these defenders looked at the judge who they had, which luckily was a judge that was pretty likely to be smart and receptive to clever argument. And also this individual, it was a felon in quote unquote in possession of a firearm. And, the evidence in these cases is just overwhelming. There's very little way to fight them. And for this particular person, the need was to mitigate its sentencing. And so they brought arguments around racial disparities in charging these gun cases in federal courts versus in state courts. And they were like, wait a minute, these are basically transfer cases. It's not a formal transfer. There's no conversation between these systems, but we all know that it's informal because the DAs on the state level drop these cases immediately if the usually if the feds take them up, because the feds can get these mandatory long terms. So they brought an argument that this was racially, that there were strong racial disparities, especially in California, around these transfer of these cases to federal court. And they got discovery. They got the judge to order the assistant US attorney to produce data on how they were charging felon in possession of a firearm on Black clients as compared to the others. And they were like, we don't keep that information. We don't track it. And the judge was like, figure it out, man. Like, you put them in custody. We all, everybody sort of knows that there are systems that have their race on them. And they got the United States Marshal Service, who rents space in the local jail, to produce the data that's in CRIMS, that's in the system that uses. And they got the disparity data. And they've been using it in every other case where somebody ends up in a similar situation. And so to me, that was such a powerful example of using a righteous argument where in this particular situation, there was so much going on against this person by virtue of their race. And this was just the tip of the iceberg, but to get a pretty powerful result in terms of information and access. And it was about audience. I mean, it was about using this particular judge, and that's just not available everywhere. But I think it didn't have, the risk of loss was not so great because it's at the sentencing phase. This isn't something that's going to kind of go up and be a big deal in the circuits. So I just thought that was a really interesting and creative example that also managed to center individual representation of somebody who's being held hostage in this legal context. And I know it's lunchtime, but please, I would love to, if folks have questions, but also feel free to step out.
I'm happy to run the mic after too. Hi, I'm Kelsey Fian. Thank you guys so much for this panel. This was really, really great. I have a bit of a basic movement lawyering question. Hopefully it's not too basic, but so I'm a former civil public defender from the Bronx. So it's music to my ears to hear the description of housing court in Philadelphia and it being exactly the same as housing court in the Bronx and just a toxic hellhole. And one of the reasons why I moved on to a human rights space, and I love what you talked about rights versus resources framework and finding the limits of that, is the time suck and the energy suck of direct services and the inability to remain in a movement lawyering headspace and posture. And even just, you brought up Andrea Ritchie and the need for technical expertise to do movement lawyering. And I found it really hard to develop that in a direct services space. I was told on my first day, no one's gonna read your brief. They're not reading it. No matter how much, you have to spend time writing this brief, nobody cares. But you all seem, I'm so impressed by your ability to stay in a movement lawyering posture despite that. And so I just wanted to hear your thoughts on, the struggle of the balance of maintaining those two things and how you're able to do, it's fire after fire after putting out fire after fire, and being able to maintain that mentality and that lens.
I'll just kick it off by saying that I can't. I'm in a public defender's office where somebody mentioned participatory defense, and an older attorney was like, "What's that?" And then was very hostile to the idea that family would come and have any kind of input, that community would come and have any kind of input. So I'm thinking about how I can do that informally. But I'd say that's one reason I wanted to have this panel is to hear, to be able to think about how to try to build it in, but so the folks that are doing it.
Well, I don't know. Okay, so and I got a couple of colleagues here in the audience also. We were having essentially this discussion with yesterday. So I want to be honest and open about this, in that I don't think that my organization does do that. I don't know if there is, at least currently, there's talks about moving maybe in that direction, but I don't think I have a good answer for you because I don't think that I'm doing that. I'm, trying to think about creative solutions, blah, 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 like trying to essentially, use a guerrilla mindset to find where are things less stacked. But in answer to movement lawyering in a legal services organization, honestly, I don't think I'm doing it. I think I got to keep working on it in order to get there. And I think it's important to move in that direction. But I don't have a good answer because I'm not doing it.
Is it on now? Oh yeah. I think specifically in the direct service context, it's really challenging, right? And I feel like we have to give like folks credit, right? Like, so I should preface, I have not yet done a direct service, job, and so that was an experience that I've missed out on, so far. I think that in the policy space, it's a little bit different, but I think definitely in the litigation space, it's like you have so many things happening at once, right? And one of the things, I guess, like maybe the indirect services is speaking about the fact that the needs are so acute and are so urgent, right? That like movements take time to develop, right? They require kind of a vision into the future of what this movement can create, or at least maybe at least in the more traditional sense, I suppose, right? Like I'm sure that there are movements that are built up overnight and like are activated overnight to like, well, I mean, it's hard, right? Like I want to give room for the need to move urgently, right? But also give grace to, again, in the direct service context, the difficulty of being able to do that, right? I think in the policy context, there is a wider kind of window, and oftentimes it's a little bit less. It's also clearer, right? Generally speaking, what your legislative cycle is going to look like. When your hearings might be, like the time window. When to prep and when the session ends, what you may be able to do afterwards, right? And so it gives you more room to be able to think out what this movement could look like. In our work, and again, with such a niche focus on juvenile fees and fines, one of the challenges we've run into as we're trying to grow into a more abolitionist organization, right, is to try to figure out and carve out where can our resources, where can our our ideas be best utilized, right? So I work in Hawaii, one of the states that we do this work in, and when we first did our research, our background investigation there, talking with local community elders and workers, their first thing that they told us is fees and fines aren't a major issue to us here, right? Like they're often waived. It's not usually something that is at the top of our list. One thing that we are very worried about right now is this bill that's in the legislature trying to create mandatory restitution for kids, right? And that's where our focus is right now. Can you support us, right? And our answer was absolutely. Let's focus on this, right? This is not usually in our lane. This is not like it's tangential at best, right? But it was a moment where we said, this is an urgent need. This is something that is in the legislature right now. They're about to have a hearing. What can we as legal workers, what can we as our student team do in order to make something beneficial in this moment? And so what we did, we took the community input, their narratives, their testimony, we built fact sheets around that. We sent that directly to legislators to be able to speak on this issue, right? And of course, having the Ivy League, the West Coast, public Ivy kind of name of Berkeley has its uses there too. It allows to kind of carry that message from the continent to the islands as well. And so I think that there's easier kind of, or probably well-beaten paths for doing movement work in the legislative space, because you have so many more opportunities to kind of use the community voice in a meaningful way. With litigation, it's so much harder to actually have community at the table speaking for themselves and you being in an amplification role. Yeah.
So I'll be quick, but I think when you're representing somebody, and I don't have near the docket, anywhere close to the docket that Bic has, right? So I take, sort of probably like 5 cases at a time. So there's like a luxury here. And also, I get a lot of fires. I've had a lot of last 2 weeks, like this fucking change in date. That was a really terrible fire. Did not enjoy that. 0 stars, do not recommend. But I think that there are fewer fires for your clients when they are connected to organizing that includes a component of collective care and mutual aid. They're not going to like, there's just, and that's why I was so like relieved to hear that conversation. Cause I've been in sort of movement lawyering spaces for probably like 5 or 6 years now. Right. And in organizing spaces for longer. And I haven't heard as much conversation about like sort of material conditions until now. And I'm really excited about that. And I think some of that has come out of the pandemic. I mean, in some places I have, but in this sort of, people coming together from across the nation and this particular, and with this sort of conservative profession, I'm happy to hear that discussion is happening, because when I refer clients to organizing, like to an organizing space, and why I felt it was so important to be a part of and supporting in whatever way I could, like I'm like a secretary. I honestly like act as a secretary to the development of that organizing space, because I think it's so important. Like I meet with the organizer that was hired. We talk once a week, and I'd like give her downloads on the meetings that I was in that she wasn't able to be in, so she can focus on base building. I'm like working on applications. I've told her, I'm like, I'm your secretary. This is something that I'm good at. I can do administrative work. That's what I did before law school. Like, cool. But that space, but I do that, and I think that space is so important, because when I refer clients out to organize, I think it's just as important as referring them out to any other service organization, because for that exact reason, because like, I do think that like 50% of the time I'm on the phone with like a client, they're just like kind of processing some stuff, and like I'm happy to be that space, and that's a need. But being able to refer them to a space where that can also happen in a generative way, in a way that makes them feel supported, and that where they're also connected, that's what, that helps the fire, that quells a lot of fires that end up taking up a lot of time, and helps us helps us as lawyers to make ourselves right-sized, and like really understand that, like treat this as just a tool, or treat the lawyering as just a tool. So.
Thank you.
Hi, and I'll try not to keep us too long, but I'm sorry you can't see me. I really have enjoyed this conversation, and I thought that a lot of what y'all brought to the table was really fruitful, and has been really fruitful. I think particularly this conversation around how you stay in movement while doing this work, particularly in direct services when you're working with particular clientele. And I agree with y'all who have talked about the importance of maintaining a community for folks, and staying situated in that community. And so I'm just wondering about your own personal communities and how you practice that outside of your work, how you stay in community with folks in movement spaces, how you stay in community with current and past clients, how you remain accountable, even if the spaces that you're employed in don't provide an infrastructure for that. How do you remain accountable to community as a lawyer?
I love that question. Thank you for it. I had the benefit of a career prior to law school, where I organized with SRO hotel tenants, and then and also did a lot of volunteering inside a prison. And so I would say one of the biggest communities that I've been fortunate to have follow me is folks that paroled, that are living nearby, and who keep me honest, and who keep me grounded in thinking about people's lives, the arc of like where people go and what the downstream consequences of these in my moment criminal cases for folks. But I think it's very challenging to stay grounded, especially like given the avalanche of cases and work. I mean, I think that's really the name of the game and the question. But it's funny, just before you asked that question, I was like, I got to reach out to so-and-so and walk, go for a walk. And like, I gotta get, and so I think it's, I think it's holding those folks in my heart and in continuing to continuing to hold myself accountable for being involved in active organizing now, as well as also thinking of, I was like, wait, we don't have participatory defense, but I know organizations. And they would come to court. I know Courage. I know these groups. If I have a young adult client, I know somebody that'll show up. Also, my friend John will show up, like Miguel will show up. Like I can call people. There's people I can call and I can do it informally. And my supervisor's too busy to tell, like if they cared. So thank you for that question. It's more, I take that in.
Well, so one thing I think is don't hang out with other lawyers. I know that's kind of a weird thing to say, but I think as a profession, don't hold each other accountable. Like right, and this goes back to this like collegiality thing that's built into our profession, and like the culture is that we look. We essentially look at each other as separate in a separate community. So on a personal level, one of the things I'm very lucky is that I have a spouse who's an artist and is really radical, and so I've been lucky that they bring me to those spaces. So I'd say when you're not at work, don't hang out with other lawyers. Actively seek out those other spaces.
I too really appreciate the question. I think for me, it makes me reflect on just all of the different procedural and institutional roadblocks that make it harder for us as legal workers, as lawyers, to connect and reconnect with community. I think, obviously the law school experience itself is one that's extremely alienating, right? And for many of us, especially for first gen, right, there's kind of this notion of, we're on this pilgrimage, we're leaving our families to go and get this knowledge and we'll be back soon, right? But like, one, is it soon? And two, do we ever make it back, right? Are really, really questions to think about. I think specifically in the crim context too, right? There's the very real challenge of the roadblocks that are created by institutions to prevent you from creating community with your clients, right? Trying to send a book for political education is this thing that you run into roadblocks to, right? Like simply sending a letter, right? Having to get things checked, right? Going in and trying to get documents from your client in person and having those things be searched, right? All of those different and then again, also the challenges that creates for your client that's behind bars, right? Does that put them in greater scrutiny or at greater risk because you're trying to develop this relationship with them? So I say, nevertheless, and I think kind of to what Karen was saying too, I mentioned previously, I have one client that, was sentenced to juvenile life without parole and was released. And I should mention it was a functional juvenile life without parole. So it was an 80-year sentence. So we argued this is virtually life, right? But that was, I think, the only kind of strong relationship I was able to develop because we were connecting on what life could look like for him after he was released, right? The things he was excited to see, right? Of course, being connected with the attorneys I worked with who told me about this after I had left my fellowship was also helpful, right? The fact that, maybe we don't want to always hang out with lawyers, right? But it's beneficial that they told me, hey, he's been released, right? Here's a picture of him. We just took him out to get, a burger or whatever, right? And so I think being able to follow along in the lives of your clients is super hard because we're so transient a lot of times too, right? But I think especially thinking about it again in the kind of policy like framework too, being able to connect with folks on the front end of your policy work is, I think, the key to that, right? And that's something that I know we struggle with as our organization because we're usually working with institutional partners, that are not rooted in this work, right? They are not going home to this work in the same ways that you talking directly with the impacted family member is going to be, right? And so we've been saying we need to go in and contract not with, an ACLU and shout out to ACLU for the work they're doing, right? But we're not trying to contract with institutional partners, we want to contract more to the extent possible directly with people, right? To say what is the policy that you want to see and how can we help you create that policy, right? So that at the end of the day, when we have a difficult decision, at the hearing where it's like, all right, we had to cut a piece of this bill out, what piece are we going to cut out? It's not us thinking strategically from an institutional and detached viewpoint, right? It's us actually listening to the people who are going to live with these consequences and say, do you want us to sacrifice this or do you want us to pull the bill and come back another time, right? And I think that's really the crux of the matter. When you've invested time, you've invested money, you've invested resources, and you want to get something across the finish line. But again, that's where our ego kind of has to be checked, and we have to remember who we're working for and how we're working for them.
Just so I'm clear, it was a question about how we maintain our communities or maintain, okay. I'll be in the streets as much as I can. And I think that this is actually something I'm struggling a lot with right now because I enjoy my job probably for the first, I like my job. I actually love my job. Not because I love working, I hate working. But I do, there's never a moment when I'm doing something that I think that I like disagree with, and it's also fun and I really like the people that I work with. And so I feel extremely lucky. And at the same time, now I'm working all the time and I'm like willing to work all the time. And that is so dangerous. And I think a lot of us have that. I absolutely have a toxic relationship with work. It's something, and I know the roots of that and I'm working on it. And I've been watching the ways that that's like popping up and the ways that I'm pressuring other people to do that. And that is a really good way to really fuck up your community. I'm watching it. And so I'm like keeping an eye on it. And I'm really lucky to be in community with organizers and just like people in Baltimore who like their chosen, activity of like leisure and fun is like carnival parties, like Juve. They go all together and like they've invited me and I'm like, I wasn't able to go to the one, but I wasn't able to go to the one that I had bought tickets for recently because I was up until 3 a.m. on a Sunday morning, finishing a brief but I cared about it. I was really into it. And I was like, this is not okay. This is actually really not okay. And the ways and so watching the ways that I'm like doing that, like reinforcing the same tenets of racial capitalism that put my clients and everybody that I work with in these positions, I'm participating in. And so I think I don't have an answer for you. I'm just like reflecting on the ways that I am trying to maintain that. And I think that's also part of why I been up till 3 o'clock in the morning because I'm so excited to see some of the people that I get to see here who are like dear friends and people that I adore. So I think for me, there's a lot of like self-work to figure out, I don't actually say like being in the streets in jest. I really just want to be in the streets and make sure that I'm maintaining a sense of self outside of doing the work, because if I don't, at some point, I'm not going to be looking to be on the beach with the mango-based alcoholic drink. I'm going to be I'm going to feel sad and depressed when the work stops. And that's so dangerous. That's so dangerous. So I would love to be in community with folks and figuring out how to do that because, and I think it's also about being right-sized. I really, I learned that from some like meditation spaces. Like what does it mean to show up right-sized? Because in a lot of spaces, because we've been trained to think of ourselves this way, and a lot of society has been taught to look at us as like on a pedestal. We were talking about this the other day, like the lawyer on the pedestal. And so that means we feel like we have more power than we do. And so we put the pressure on ourselves to act as though we have that power, but we really do not at the end of the day. And so being able to respond to every single person who's calling you at every moment, but have, clients that are pushing on boundaries that you set, like, and feeling guilty around that, or feeling like you have access to something and this person does not. And so you always have to give everything all the time, is giving into that. I know it's extremely hard because if you have a tool, you want to share it and you want to share it with as many people as possible. At the same time, the way that I've been thinking about it is like, if I am making myself available at all hours or whatever, working all the time, then I am thinking of myself as as the solution, and I'm not. We all have to do it together, and I'm not giving space for somebody else to be, share their tool, which might not be the law. It might be organizing. It might be sitting on somebody's porch for hours and listening to them, listening to them talk about what they're going through. And so I think those are some threads that I've been ruminating on a lot, but I just definitely don't have the answer. But I want more answers. Anybody else have an answer? I would love to hear it.
I want to throw, if I can just throw.
Yeah. Thank you for that question and thank you for the answers, y'all. So for me, I think being clear that, and this is why I sometimes struggle with the kind of dichotomies that I hear when we talk about community and lawyering, or lawyering and organizing. And, I want to be clear that I understand the intention of making those distinctions, because historically and currently, sometimes us as lawyers show up and take up all kinds of space, and more than taking up the space, don't have a power analysis of the power that we have in situations. So I understand how come we have those distinctions. And my experience is sometimes we take that so far in a way where it becomes this assumption or a presumption that I, lawyer, am somehow inextricably disconnected from the communities that I'm working in. And unfortunately, that is a norm for some of the spaces I'm in New Orleans, a city that is simultaneously very local and very transient at the same time, in the same place. And so for me, what helps me to not have an answer, but to struggle, in a way, is to remember who the fuck I am and who the fuck my people are. And remember, my people are in the room with me and are watching me and love me, because love is necessary for accountability. And them challenging me is a part of that accountability, is a part of that love. So for me, being clear that yes, I am a lawyer, yes, I'm barred in Louisiana, and I'm not so disconnected from the person I'm representing, because we literally went to the same high school or literally grew up on the same block, or those sort of things. So being clear what that means in connection with something else. And to me, of course it's challenging, because yes, we have these things that are the same, and there are some clear distinctions in terms of who gets to stand up and argue and who's sitting there. So not to invisibilize that, but that's something that helps me stay grounded, is being clear that my people are next to me and in front of me and behind me and all of that. And that's something that I hope that we in this space and others can interrogate, what does it mean to make the kind of lawyering, organizing kind of dichotomies? When is that useful? And when is it actually hindering our ability to be accountable? Because if I inherently say that I'm different, how am I able to see the parts of ours that are connected in order to tear this shit down? I was in a space one time talking about housing, and an amazing attorney who I have a lot of respect for, who defends tenants facing evictions all day, every day, was talking about renters in New Orleans. And in this third person, I said, person, you're a renter. I'm hearing you talk about this thing as if it doesn't impact you. You are impacted by bullshit 200-year plus renting policies in Louisiana. Yes, sure. No, you're not a Black person from New Orleans for generations. This is true, but how have we taken the I'm not directly impacted so far that you're fighting day and night for some shit and not putting yourself in the conversation? So it's just I don't know if the word is balance, but just that's what helps me, like, to remember that I am, it's not some over there and we're over here type thing.
I just want to thank you for that, because in the criminal context, it is so easy for me to forget that I too am affected, because I'm not directly affected in the same way. And that is like so well heard. Yeah.
I'll just say really quickly, I resonate with that, and it was, I think that was on my spirit too. This notion that, like, we have a kind of martyrdom complex, right? Again, we leave the home thinking we're about to come back with bring back all of this knowledge, bring back the swag, and et cetera. But I think the dot that you kind of helped me to connect for myself, right, is that because of the martyrdom complex, and until we relinquish it, right, we do not see ourselves as in need of care and susceptible to care, I guess, right? Because so you're in this housing example, it's so much so true, right? It's like, yes, we are suffering under these same conditions, right? But then the first thing you'll think is, well, I get a higher salary than you, right? And I'm not in the same situation as you for XYZ reasons, right? It's not nearly as hard on me as it is on you, and that's why I'm sacrificing, the things that I may need in this moment to help you, right? Because I've chosen this route for myself, right? We've committed ourselves to this practice, right? And I think maybe that's the way that we need to kind of redefine what this practice is, right? It's less about it's less about the courtroom, it's less about the brief, and it's more about the community and caring for ourselves as part of that practice, right? And I think that's definitely definitely has been erased from any concept of legal practice, right? And is desperately needed. We appreciate that. Thank you. I think we're at 12:30, and I know everyone got to eat and refuel. So shall I pass it to you, Karen, to wrap us up?
I just want to thank all of you so very much. And I wanted to know if you guys had any very closing words. No.
Well, yeah, I mean, again, we're at a conference on lawyering for liberation, right? And I think for me, the moment, right, when we're thinking about the decks being stacked makes it hard for us to fully envision what that liberation might look like. You know what I mean? I think for me, the thing that I'm taking away is that, again, the decks have been stacked in one way or another forever, right? This is not a completely new moment. There was a Twitter thread from Nico Bowie, a professor at HLS, that really, I think, inspired me. I think it was immediately post Roe, where it was saying, we've put so much trust in the federal courts. We thought that if we wrote the right words, the smartest words we could, the right interpretation, that the smart people on the bench would hear us, they would connect the dots for us, and they'd give us the rights that we think we need, right? And if that was ever true, it's certainly not true anymore, right? And we need to retool ourselves in ways that are going to prevent us from kind of falling into that trap, right? Where we're getting constant liberal and progressive argumentation that we just need to vote harder, right? And if we keep voting as hard as we can, then one day we'll have what we need, right? When currently we have, so many things in our favor ostensibly at the federal level, but the mechanisms are not working, right? The courts aren't working, the Congress isn't working. And we're allowing excuses in many ways to prevent the change that we need from actually occurring. And so rather than wait for those things, I think the moment that I'm thinking about now is how do we shift the resources away from the federal? How do we shift them back to our states and to our communities in ways that will allow us to push forward while we wait, at the very least, right? If we choose to wait for anything to happen federally.
I think there's just like one more thing that I would add, is that it because we've talked a lot about it, sort of implicitly, we've talked a lot about litigation, because I do a lot of it, we all do some, and you do policy stuff. And also I really don't want us to lose sight of the power of sort of coming up with like turning towards cooperatives, turning towards land trust, turning towards tools that are turning towards systems of thinking about resources that are connected to the values that underlie those tools, because there are so many other things that we could come up with. And this brief story I wanted to share is I work with a group that's trying to put together a grocery store, a Black-owned grocery store cooperative in a part of Baltimore City, South Baltimore, Cherry Hill, where there has not been a grocery store for decades. And I was supporting them in their bylaws process. And that we did a participatory bylaws process intentionally, and it took so long. It took so good Lord, it took so long. And because I and another person on the steering committee, we were walking everybody through every single piece of those bylaws, and we were making decisions collectively and on every single piece of it. And there were so many times where I was like, fuck, I should have just drafted this and like sent it to them for review. Like, have I fucked this up by not being urgent or not completing this urgently? And when we came to the end of it, honestly, I was almost in tears because when folks were reflecting on the process, I was realizing that there were so many like little tiny pieces of the bylaws that we created, and like the little tiny ways that we were thinking about self-governance that these Black folks had never been invited to do before. And so we had these conversations about together realizing how much of our governance we give away without even thinking about it, how much of our self-governance and accordingly also our own power we just give away to like let somebody else, the government, which is us, right? The government is us. We keep talking about the government. We talk about the state as like the state TM. It's us. If we all stop paying taxes tomorrow, that would be the end of the state. There would be no more state. And so like I think that exercising those kinds of tools and like, local self-governance is extremely anarchist, and not anarchist with like a big A with the circle around it and like, punching people at the shows or whatever, because that's what I grew up thinking anarchism was. You just like punch people in the mosh pit and like, that's it. I was wrong about that. I'm so sorry, Lucy Parsons. But hyper-local governance where you gather resources and you do things together, like that's abolitionism. That's what abolitionism is. That's the kind of thing that we're working towards. And so I think flexing those muscles and supporting people in flexing those muscles is just as important as all of this litigation, because it moves so much away from us and invites so many people to be thinking about how they can build things for themselves and like hold resources for themselves and not depend on the state to do it. So that's my last piece.